So, we are the steering committee of the Illinois Accountability Coalition. And thank you for having us here today to talk about the work that we're doing and the important accountability reform that we're hoping to advance across the state. So I'll just briefly go over the members of the former Massey Commission just for a little bit of history on how the coalition really got started. So, the Massey Commission was a citizens commission established in response to the tragic killing of Sonia Massey in Sangamon County. Their mission was to take action to make recommendations to expand safe and equitable access to services addressing systemic racism, mistrust in law enforcement, and other helping professions. So, under their truth and accountability pillar, which calls for transparency, acknowledgement, and responsibility across every public system, they included as call to action number 10 to urge the Illinois General Assembly to enact qualified immunity reform to strengthen civil rights accountability. That was as a result of presentations from my colleague Chad at Americans Against Qualified Immunity and Amy at Care for Victims over the summer when the Massey Commission was hearing from members about potential reforms to recommend for increasing accountability across the state. So that was successfully adopted and pushed forth as a call to action. The Massey Commission has now sunset, but we have members of the former commission. So Adam's on the call. We also on the coalition have Kelly Hurst, Dr. Kelly Hurst, who was the managing director for the coalition, as well as Sante Massey, who was a member of the coalition and a family member of Sonia Massey. Sunshine Clemens was also on the working group, Veronica Espina. So we have several members who were involved in this process who are now involved with the coalition. Go ahead, Amy.
A little about us as far as an organization for care for victims. We're really focused on improving the justice system experience for victims of crime. And CARE is actually serves as an acronym, and that represents the three things that we heard victims want and need most out of the justice system, but is still lacking. So first and foremost, they're looking for compassion for what they've been through, what they've been put through, and what they're now having to navigate going through the justice system. Secondly, they're looking for accountability, again, for what's happened to them. That's why they're coming forward and reporting these crimes. And then lastly, they're looking for rights enforcement, which is really going to be the focus of our presentation today. When we talk about rights enforcement, we're talking about the enforcement of victims' rights. From those core priorities, we developed our organizational objectives. So again, we want to educate and promote awareness of victims' rights, in addition to supporting agencies that are available in our communities that help victims. And that's been one of the biggest areas for awareness, is just how many people are not aware of victims' rights or what they are. We also, from a bigger, higher perspective, want to improve justice system and government transparency and accountability. And then also identify and eliminate justice system and government loopholes and where corruption potentially resides within those loopholes. And then lastly, again, improve victims' rights and enforcement of those rights. So usually right now in this type of presentation, we ask a series of questions just to gauge the audience's understanding of victims' rights. My guess is, given your backgrounds and the work that you do, you're probably more familiar. So it may not be as pertinent, but just real quickly, just by a show of hands, how many of you have heard of victims' rights and know what they are? Can anyone name some of the victims' rights?
I believe they have the right to information about what's happening in their cases. They have the right to be told when someone is convicted and also if someone is released who committed a crime. And I believe they have the right to some sort of support in the form of counseling as well, but I'm not clear on that, as well as a right to recovery of assets to the extent that the person who committed the crime has assets that can be recovered.
Sure. That's good. Good. Anyone else want to take a stab at it? So that's good. And so with that, within the criminal justice system, who represents victims of crime in a criminal case?
In theory or practice?
In practice.
Practice, nobody. In theory, the prosecutor.
And that is something that we also try to bring to the awareness, because a lot of people assume it's prosecutors when, as you know, they don't actually represent the victim. And so that really leads to the question then, who is representing the interests of the victims in criminal cases? And that's, again, why we have these different victims' rights. And again, to kind of just reinforce why we do this, conversely, who's heard of Miranda Rights and know what Miranda Rights are? Right, everybody. And so that's a thing that we could try to highlight is, why do we know more about the rights of the accused than we do the rights of the abused. And again, your group is much more knowledgeable about this than the typical groups and organizations we go out to. But again, something that we're trying to elevate and bring awareness to if we're really thinking about a fair and just, impartial justice system. So again, when we talk about victims' rights, there are a number of different documents that are out there and available. This was gathered from the Illinois Attorney General's website. And what we're hearing is that most victims do not know about victims' rights. They're not being told about them. They're not being provided to them, even though now legally victims of violent crime are supposed to be provided a copy of their rights, signed off on them within 48 hours of reporting a violent crime, which is this document to the bottom left. Again, based on some of our research and audits that we've conducted, we're seeing consistently that is not happening. In addition to that, Nancy, you had a question?
Who's responsible? Is it the police that's responsible for giving them that
Correct.
information? Okay.
Law enforcement. It's part of the Crime Victims' Rights Act that law enforcement are supposed to have them basically give them that bottom left document. And there's a section at the bottom that they can sign off on. And so what you see here to the left is just the Illinois Crime Victims Bill of Rights that's been added to our Illinois Constitution. And then this middle document is the Notice of Victims' Assertion of Rights that they would have to sign off if they want to assert their rights, but not for all rights, for some rights. It's not clear, especially from a victim's perspective, when they have to do this. There's another document, Understanding Illinois Crime Victims' Rights, FAQs, that you can access. But again, if you don't even know that you have rights, you wouldn't even know to find this document. The document that you're supposed to sign off on, and then this document to the right, Enforcement of Crime Victims' Rights. And there's another document I didn't list here, but if you have a complaint of rights violations, you can submit a victim's rights complaint to the Illinois Attorney General's office as well. But again, our point here is most victims don't know about these rights. And because you don't know about your rights, you definitely don't know how to enforce your rights. And then the second problem we're finding is if you do know how to enforce your rights and you try to seek out an attorney, most attorneys are not taking on these types of cases. And so part of our work, we wanted to build out a victims' rights attorney roster to help facilitate that process for victims. So it's just one less burden that they have to take on themselves, spending weeks, possibly months, trying to search for an attorney that will help them with their case. And what we found consistently is that most attorneys won't take on these cases. And the number one reason they cited is because of qualified immunity. And they said it's not worth their time and effort to try and take on these types of cases, especially if they're pro bono or contingency fee, because most of these cases are going to get thrown out. Looking at that type of systemic problem, we started to do some additional research, and that's really what led us to the connection with Institute for Justice and the Americans Against Qualified Immunity. Because again, part of our mission and our objectives is rights enforcement. And if we have a doctrine out there that's basically nullifying the ability to enforce these rights, that's something we need to address systemically. So with that, we were connected with IJ and Americans Against Qualified Immunity. And from here, I'll go ahead and transfer things over to Chad Reese. And he's going to talk more about the work of IJ and ending qualified immunity.
Yeah, thanks, Amy. I will start by saying we're in dangerous territory. I'm a policy guy, and I am talking about a judicial doctrine to a group of attorneys. So I want to approach this with some humility. I will probably be discussing things that you all would like to move quickly past because they are very basic and very well understood already. If I do go too fast through something that anybody wants to linger on or kind of discuss, please don't let me control the pace. I would like this to be as discussion oriented as possible. So if I skip over something and say, oh, you guys probably know all about that, feel free to stop me. Or if you think that I've got something a little bit wrong and you want to kind of dive into something, I would love for us to kind of all be on the same page as we go through here. So do influence the pace as much as possible, and I'm happy to have the conversation. Some of you might already be familiar with the Institute for Justice. We are first and foremost a public interest law firm that operates on constitutional rights abuse issues. We represent clients pro bono in those cases. And our Americans Against Qualified Immunity effort really grew out of our project on immunity and accountability. As you all might imagine, if you are in the business of filing lawsuits for people who have been the victims of constitutional rights abuses, you run into immunity doctrines quite frequently, and you become very familiar with the ways in which they can block access to the justice system. So that's kind of where we come from as a grassroots initiative. Some of our work in this space is on the litigation side, and we have teams of attorneys who directly challenge qualified immunity doctrines, as well as other immunity issues. We have Bivens cases, for instance. We also work on state-based legislation. We have Noah on the call, who is our Illinois legislative strategist, but we've worked in other states. I've testified in Maryland. My colleague Ellen on the call has worked for a long time on a bill in New York. And our organization worked very closely with other coalition members in New Mexico to pass their state-based qualified immunity reform. And then all of us from IJ here are also part of the activism team, where we think it's very important to make sure that grassroots voices are not only heard and are part of the conversation, but are really leading these efforts. So that is the specific team at IJ where the Americans Against Qualified Immunity Initiative came from. Here's one of those moments where I will be fairly brief. I suspect those of you who are practicing attorneys have at least heard of qualified immunity. I will say it is important because there are a couple of Supreme Court cases in history that mention something called qualified immunity. When we talk about it, we are citing the specific doctrine created by the court in 1982. So we're going to be talking about the clearly established doctrine and that version of qualified immunity rather than the example that was really something a little bit different from the 1960s. But fundamentally, when we talk about qualified immunity or QI, what we always stress is that it is a legal doctrine that protects government officials from civil lawsuits. So we mentioned it doesn't come up necessarily in criminal cases, but if your rights were violated, it is a significant hurdle and roadblock to having a court recognize the violation of those rights, and importantly, identify and provide any kind of redress for those violations. I mentioned the clearly established doctrine that we mostly focus on, and that is kind of the essential component of the modern doctrine of qualified immunity that the Supreme Court has attached to Section 1983 lawsuits, which, again, as I'm sure many of you are familiar with, those Section 1983 lawsuits are the primary way in which any American who felt their rights were violated by a government official would be able to get their foot in the door in a courtroom by saying, I would like to sue under this federal statute. When the Supreme Court attached qualified immunity from civil lawsuits to Section 1983, they created essentially that two-step test. First, a court is ideally supposed to identify whether or not the official actually violated the constitutional right. If I was pulled over during a normal traffic stop and the police officer had no reasonable cause to search my vehicle and they did so and I sued them, the court should theoretically first say, yes, you were the victim of a warrantless search without probable cause or any other judicial doctrine. They should then, according to the Supreme Court, move to the second part of the clearly established test. And this is where things get particularly tricky for those who have their rights violated, because clearly established seems like a reasonable thing in the abstract. It's the court saying, well, if you're a government official, you have to have had some kind of warning or some kind of heads up that the thing that you were about to do was in fact a violation of a right. Unfortunately, what we do know as a law firm that litigates in these issues and as a legislative team that studies this policy area and as grassroots team that meets with the victims of constitutional rights abuses all the time is that the way in which courts have interpreted that clearly established definition has radically changed from that sort of understandable, maybe general language idea. It's no longer the case that I present my case and say, well, my Fourth Amendment right was violated because this was clearly unreasonable. And here's what happened. A court now might say, well, I need you to find me case law in the same circuit or at the Supreme Court, wherein the facts of the case match on precisely to what happened to you, such that the rights violation was clearly established. That's problem number one. It's very difficult to find very specific case facts if courts decide to interpret those case facts incredibly narrowly. The second challenge, of course, is that courts routinely and increasingly skip question number one entirely. and don't feel the need to determine whether or not a violation occurred in the first place. What that means is clearly established gets harder to prove over time because you don't have case law in the past. It might be one thing if courts were aggressively saying, okay, you didn't have heads up this time, but you violated a constitutional right. So if it happens again, you're officially on notice. Instead, if they never officially put government officials on notice, then the case law, the precedent doesn't get established. And again, we find ourselves in a more and more narrow situation where victims can't even get the merits of their case heard. So some of these are probably, I think, at least I hope, are obvious from what I've already said. But the reason qualified immunity reform is particularly urgently needed is because of the way it's been interpreted in that most recent 1982 case by the Supreme Court, and the way in which those tests, as difficult as they are to overcome, have increasingly narrowed the window for people to have their rights vindicated in court. We know that misconduct happens, and we know that when it does happen, it often goes unchecked and the victims are left uncompensated because of qualified immunity. Institute for Justice has done significant research on this. We have some interesting research documents we'd be happy to share with you all. But the violations and the harms go well beyond what you might see in the news. One of our clients, and I mention this particularly because it's relevant to the clearly established challenges, set up a parody Facebook account for his local town police department. A fairly standard use of the parody provision of the First Amendment to make fun of the people who have power and wield power in your community. The police department in this town, perhaps predictably, did not find this amusing and chose to raid his home, arrest him, and effectively charge him with, I believe the best way to describe it would be sort of cyber hacking laws that were designed to stop people from messing with 911 systems. In a sense, the police were trying to argue that a parody Facebook account so confused and bamboozled the emergency response capabilities of their town that this person was the same as a terrorist hacking into their 911 components and rendering them unable to deliver emergency aid. Now, what happened to Anthony Novak in that situation? The court said, first of all, sort of dismissed the idea that having your home or apartment ransacked by police and thrown in jail was a harm at all, because they said, well, you weren't convicted. The charges were dropped eventually. They let you out. No harm, no foul. Who minds a few days in jail? No big deal. But the other truly disturbing component of that particular case is they said, well, we know that parody and satire are well-developed aspects of First Amendment freedom of expression and freedom of speech law. But this happened on Facebook, and we just don't have good case law about whether you can do parody on Facebook. Now, that tells us two things. One, it rewards government officials who become increasingly creative in the ways they violate your constitutional rights. And two, because technology, by definition, changes over time, it becomes incredibly difficult for slow-moving courts to keep up with those sorts of things. So the next person who comes along in Anthony Novak's situation will probably face the exact same challenge that he faced in trying to get justice. And that's number two. Courts don't clarify the law, stunting the precedent and case law development of civil rights. I won't go too much into detail on point three because I think my friend from Care for Victims identified this really well, but qualified immunity makes these cases incredibly difficult and expensive. A lot of very honest, very decent attorneys will simply tell clients, I'll represent you, but I don't think we can be qualified immunity. And I can tell you that we're going to have to appeal probably at every level before we can even start talking about your actual case. And that's going to make this a very expensive proposition to get through. So we think it's vital to make sure that there is a reason for attorneys to take these cases. It's also, I think, obvious that public trust is eroded when there's not an accountability mechanism, particularly if the criminal justice system also does not hold individuals accountable who clearly violate the law. If they violate the Constitution and victims get nothing, then we learn not to trust government officials with that kind of power. And one point that I always like to bring up too, particularly since the Institute for Justice doesn't work on a number of other criminal justice reform issues, is that you can have the best mechanisms for accountability in other facets for your local police department or your local tax auditor or your health department. These can range from regular audits, best trading practices, body cams. But if you can't sue when those rights are violated or when they fail to uphold those standards, then those reforms themselves can become meaningless. So again, qualified immunity not only for finding legal representation, but also for upholding other accountability reform measures becomes a vital linchpin reform piece. That brings us to the Illinois Accountability Act, which has been mentioned a couple of different times. This is the piece of legislation that, working with the Massey Commission, working with Care for Victims, the Institute for Justice, and other organizations, has put forward to try to curb the worst excesses of qualified immunity abuse in the state of Illinois. It's very similar to model legislation that the Institute for Justice has promoted for years, including what passed in the state of New Mexico. I'll just run down very briefly so we have time for plenty of Q&A at the end, kind of what we see as some of the core components of that law. The first and most important, obviously, is that it creates a state-based cause of action for violations under the Illinois Constitution. We're no longer tied to the Section 1983 statute to bring these cases, which frees us, particularly because it prohibits the use of qualified immunity specifically, from that judicial doctrine. We're moving to a different statute, a different cause of action, and we're explicitly barring the use of qualified immunity as a defense. Another component that I always want to mention is it does require public bodies to pay damages and attorney's fees. So this is a couple of components in one. First, the attorney's fees issues I mentioned before. That's important because without these, it does not become profitable for attorneys to take these cases. And we're back at square one, where even if you've got a great case, even if QI isn't a huge hurdle, you can't find anyone to take your case. But we also think it's important to make sure that the agencies and the departments that are in charge of the hiring, the training, and the firing of individuals, and who are much less likely to be rendered or declared judgment proof by a judge, are the ones bearing the financial cost. That's because at the end of the day, individuals are being harmed by constitutional rights violations, and we want to make sure that they're actually being compensated in some way to reflect those harms. It also eliminates statutory immunities and limits on damages and liabilities. One of the things I always mention here, because eliminating statutory immunity can throw people off a little bit, is that usually these cases are not clear-cut. There might be a statute of limitations in place on a similar cause of action that makes you think, well, couldn't we just put that in place here? But if I am particularly wanting to sue over a use of force violation for my local police department, there's a pretty good chance I have been charged with assault on a police officer as part of that. Now, we find in a lot of these cases, those charges get dropped. They are often added at the point of arrest. But even if those charges are initially dropped, you're trying to find a criminal defense attorney, you're dealing with that process, and you probably need time before you can even get to any kind of civil action in the first place. So we wanted to make sure that you didn't have a shot clock running down in order to actually bring an effective legal action in this case. It also does allow the claim to continue after the death of a party. We do not want to reward, particularly in an egregious abuse of force case, someone who goes an extra step and actually ends someone's life and says, well, now the potential victim can no longer sue me. That would be an egregious oversight. So we want to make sure that families and those affected, particularly in the case of loss of life, can still continue to bring these claims. There is a public record keeping mandate. We think that's important for ongoing public accountability. It waives the sovereign immunity component for state and public bodies, which is, again, a sort of essential to making sure they are the ones who are paying damages. And it does include a provision that makes it easier to terminate officials. Now, we wanted to be very sympathetic and understanding and not violate the due process rights of government officials themselves. So we did work with labor attorneys quite substantially on this. And sort of the way we settled on it is to make sure that you can use these findings as per se evidence in whatever the process exists right now. So it works within the existing arbitration or termination process, rather than doing some sort of automatic termination or anything like that that would not allow for nuance and collectively bargained rights to be maintained as well. I've mentioned New Mexico as one of the states that this probably matches onto their reform most significant, but I always mention these as the two states that have reformed qualified immunity the most significantly. Qualified immunity in Colorado, of course, was curtailed for law enforcement specifically. And they also went with an individual liability on the officer who would commit the offense rather than sort of a public body liability, and that does come with a damage cap. Now, New Mexico's is more like what we have laid out in the Illinois Accountability Act, where it's the public body that faces the financial liability, and it also does explicitly prohibit the use of qualified immunity.
Perfect. Now I'm going to hop back to the grassroots aspect of it all with the Illinois Accountability Coalition, but thank you, Chad, as always, for an incredibly robust and clear breakdown of qualified immunity and our legislation to promote accountability. So yeah, just to wrap on our presentation, what joining the Illinois Accountability Coalition would entail. So our goal in this coalition work is to build a broad, credible, community-rooted coalition that is showing lawmakers across Illinois that Illinoisans are supporting meaningful accountability reform, and they're supporting it now, and they're willing to fight for it. So we want to act on the timeliness of the recommendation from the former Massey Commission, that call to action number 10. We know that there have been past efforts in the state to pass legislation around qualified immunity reform. We're in conversations with those groups who were working on that, as well as the legislators who were involved, whether it's the SAFE-T Act or the Bad Apples Act. And we're hoping to bring the lessons learned from those previous battles into our battle for Senate Bill 3699, which is the current bill number for our Illinois Accountability Act. So in joining the coalition, we're trying to build, like I said, a credible coalition that's comprised of individuals as well as organizations. And the reason for that is we've had several conversations with legislators who, have said, well, show me who across the state is supporting it. Like, as all good legislators are going to want to say, they're going to say, okay, well, who's supporting this? Who do you have on your team? So we're trying to build a big team. So to ask to join the coalition, there's a base level participation, which just involves adding your organization's name to the Illinois Accountability Coalition letter. After this meeting, I'll follow up with all of these resources that I'm about to go over. So no worries if you're like, what's on the coalition letter? You're going to get the letter, so you'll be able to see it. But the coalition letter basically just asserts what we just talked about, which is we are the Illinois Accountability Coalition. We believe that accountability is a crucial principle in the state and across the nation. And we believe that qualified immunity is a huge barrier to that. So we're asking you to support reforms that end qualified immunity at the state level. That's essentially the coalition letter. And that is the steering committee, who's on the call right now, as well as any other interested organizational supporter. And we also have several individual supporters who are engaged in grassroots actions, who have signed our Illinois Accountability Coalition petition to support the bill. That's separate from the coalition letter, but it is a resource that you can share with your members of your own organization. So in addition to adding your organization's name to the letter, you also give us permission to identify your organization as a member, as a partner in the coalition, in conversations with legislators, with community leaders, and with constituents to, again, say, this is who's on board, this is who's on our team. We know that the key to building strong coalitions is partnering with organizations already on the ground to tap into existing networks, existing awareness, and we're trying to amp that up as much as possible, upstate, downstate, all across. And then staying informed, we'll share our upcoming events, our advocacy opportunities, and coalition updates. We were just at the Capitol at the end of April talking to legislators, doing a check-in about where we're at in our coalition building, where we're at with sponsoring for next year. We really had our bill introduced this year as a placeholder to get a bill number to rally around. As you all know, it's much easier to direct people to the work that you're doing when you have a bill number associated with it, and it's not just an idea. So it was really important to us to have our language cemented as a Senate bill this year, which we succeeded in doing. And now our work in the interim is going to focus on continuing to get more co-sponsors added onto that bill so we can really hit the ground running next session with the coalition that we've built. So that sort of brings me to the ways that coalition members can deepen their involvement. As I was sort of mentioning about the individual petition, coalition members can share our resources with their members, with their networks, with their communities. So we already have several existing resources, grassroots actions that people can engage in built out. So we have a petition that people can sign on to that goes to lawmakers. We have templates for contacting lawmakers directly to ask them to support accountability reform, meeting requests. We also have the ability to work directly with individuals or community groups to co-host a discussion or listening session about qualified immunity and about qualified immunity reform in Illinois, whether that's a church group, a mom's group, a nonprofit, a neighborhood association. We're really able and willing to work directly with anyone who says, you know what, I really agree with this. And I know a group who would too. And I would love if you guys would be able to talk with me to that group to share this idea. We're happy to do that. And our coalition partners, we would love to be connected with opportunities like that. And then finally, participating in coalition events. Like I mentioned, we had our Capitol Day at the end of last month. We're going to be having meetings with legislators in the interim. We have some pretty strong Chicago options for co-sponsors. Obviously, we're trying to get as diverse of an array regionally of co-sponsors as possible, but we do have some solid potential co-sponsors in the Chicago area. So those meetings with legislators, those would be open to our coalition partners as well. And then we're also hosting a large event this summer, July 11th in Springfield. It's going to be the Break Light Block Party. It's going to be a big community organization event where we bring out the community to really learn about qualified immunity, as well as, just engage in mutual aid and support. So we're going to have free brake light repairs. We're going to have food. We're going to have bouncy houses for the kids. And we're going to have a lot of other organizations who are supporting the Illinois Accountability Coalition tabling. So one of our partners in this work is Impact for Equity. They're your neighbors right up there in Chicago. They do a lot of work with the Freedom Move Coalition, which is about, traffic safety violations. And there's a really strong intersection there with constitutional rights and constitutional rights violations, and therefore qualified immunity. So we're hoping to have them have a table set up to be talking about some of that. We're going to have some health partners from Molina Health doing free screenings. It's really just going to be a great event. So that's another option that you guys could be participating in or sharing with your networks if you know anyone in Springfield who'd like to go. So that's it from me. That's what joining the coalition would be like. That's the legislation. And yeah, we're happy to answer any questions now or if they come up after this. And like I said, we'll be sharing all of those resources for you to be able to make a decision, however that decision-making process goes. But thank you again so much for your time. And yeah, happy to answer any questions now.
Okay, well, I thank you for that presentation. Like I say, I'm sure we'll be back to you very shortly to say we want to sign on to the coalition. This is something that we've been supportive of for many years, actually. So we'll be on board with this, I'm sure.
Well, thank you very much. And yeah, I'll get those resources to you this afternoon.
That's great. And we may even be able to get somebody to come down and do a table at the Springfield event.
That'd be great.
We'd love to have you.
So, and anything we can do, we'll be happy to work with you on supporting action on the bill, whether it's getting witness slips or testifying or doing
great.
Yeah, excellent.
Thank you so much.
Thank you for your time. And thank you to Laura, Chad, and Amy for such a great presentation.
Yes, thank you. You guys are all welcome to stay on if you wish for the rest of the meeting, but we understand if you need to go do some other work. Drop off.
Well, I hope you enjoy the rest of your day. Thank you so much. Have a good weekend.
Thank you.
Have a great weekend.